Manuel qualified to practice law in Nigeria in 2015, and since then he's garnered such a wide spectrum of experience in labor and employment law courts, banking and finance, and basically the whole spectrum of commercial law practice. He's also a prolific writer, has written several articles in the subject area, is a contributing author to many employment law publications, including the popular Employment Law Review, which is a UK-based publication reviewing employment law practices across many jurisdictions across the world. And of course, is a member of our committee, the Employment and Industrial Relations Committee of the MBSBL. And we're glad to have Emmanuel this morning to be part of this panel on reimagining the labor act. Welcome, Emmanuel. Mr. Thompson Akpabio is online. Mr. Akpabio is a lawyer, a charter secretary and administrator, and also an industrial relations and HR practitioner. So he wears many hats, multidisciplinary experience. He's currently the deputy director and handles the legal affairs of the Nigerian Employers Consultative Association, which is the umbrella body of employers in Nigeria. Is an alumnus of the University of I'm sorry about that. University of Uyo in Akwa Ibom, where he was qualified to practice law in Nigeria in 2002. Mr. Akpabio has been involved in legal practice, working with such reputable law firms as Chief Ape Babalola's SAN's firm in Ibadan. He's worked in Port Harcourt, and for now, he works with NECA, where he's helping to douse some of the tension in the employment law space by speaking on behalf of the employer. So it's
policies to ensure compliance with statutory, judicial, and regulatory standards. He also advises and supports foreign clients in compliance with Nigerian immigration procedures and requirements. Ogona has significant experience in labor and employment litigation at the National Industrial Court and the Appellate Court. He is a member of the Employment and Industrial Relations Committee of the Nigerian Bar Association on Business Law, Section on Business Law. He's also a member of the Employment and Industrial Relations Law Committee of the International Bar Association. He served as a member of the Commercial Law and Taxation Committee of the Lagos Chamber of Commerce and Industry in 2020. Ogona has been ranked by Legal 500 as a rising star in dispute resolution and by ITR World Tax as a highly regarded individual in tax controversy. Let's welcome Ogona. Thank you. Okay, so I'm going to move to the other panelist who is online, and that's Mr. Ijeoma Agwele. He is the co-founder and chief executive officer of Verify Me Nigeria. He is at the forefront of driving financial inclusion in Nigeria and Africa by building products that connect businesses to trusted identities and customer analytics. Prior to being the CEO, Ijeoma was chief operating officer, building the operations infrastructure from ground up. Since its inception in 2017, Verify Me has become a leading KYC startup in Nigeria and now counts 60% of Nigeria's commercial banks amongst its customers. As a leader in the identity ecosystem, Verify Me co-developed an inaugural 2022 industry report with Dalberg Advisors entitled Digital ID Nigeria, the State of the Industry. Ijeoma is a seasoned enterprise architect and business transformation expert with almost 20 years of experience in building products and enterprise architecture across several sectors, including telecoms, banking, and aviation. Proud to verify me, he was a portfolio manager with Mantech International Corporation, an international engineering company. At Mantech, Ijeoma reported to the chief operating officer and managed a staff of about 80 engineers and senior managers. He was responsible for priority enterprise and solution architecture programs across US government agencies related to business transformation, where he led programs to align with agency mission, business architecture, and IT assets. In 2012, Ijeoma led and delivered the technical reference model for the US Veterans Affairs, which manages the technology roadmap for the 140 billion agency. Let's welcome Ijeoma, please. Thank you. Jamil, over to you.
Okay. No, I'll use this, but I think they might need that. Okay, so I'll just do a quick introduction of what this panel discussion is about. So, of course, I mean, almost everybody has heard about the Labor Act, and it is really the primary and main legislation we have when it comes to labor and employment law in Nigeria. It is an act that's probably the most discussed legislation in the subject matter area, and for good reason. It's the foundation of all minimum labor standards in Nigeria. And unfortunately, it's a 1974 act, if I'm not mistaken, and we've struggled over the decades to even have one amendment. Several bills have been pending at the National Assembly, but we're still stuck with that Labor Act. So we're thinking, in the absence of an amendment, we've had the National Industrial Court try to find a workaround the seeming inertia of the legislature to make the Labor Act work, give life to it. And we just want to see how we can make the best use of the act as it is. Is there a way we can reimagine the Labor Act, both in its adoption, its implementation, and maybe reading the provisions of that act in another way, giving it interpretative efficacy? Is there a way we can reimagine the Labor Act to achieve its core purpose, which really is to assure basic minimum employment rights to workers and throw Nigeria into the league of nations that its workers enjoy the notion of decent work? So we have a great panel that has been introduced, and we will be sharing ideas with them on so many areas of the Labor Act and see how we can move forward the conversation beyond the problems and get into solutions mode. So the first question really will go to Mr. Akpabio. And, following from my introduction, Mr. Akpabio, there's been so much talk about the inadequacy of the Labor Act. As a stakeholder in the sector, from the employer side, do you think that viewpoint is totally justified? Is the Labor Act totally inadequate? Is it a little bit adequate? Or you think it's just fine as it is and we just need to look at it from another angle? What are your thoughts, sir?
Good morning, everybody. Can you hear me? Maybe I can get a knob or a sign or something to know that I'm audible.
I think you may need to speak up more.
Can you hear me, sir? Can you hear me, sir?
Yes.
Am I audible? Thank you so very much. First, I bring you greetings from my DG, Mr. Wallace Matoyende, DG NECA. And we also want to say thank you for having us participate in this very important discourse. In your opening speech, you alluded to the fact that our Labor Act is since 1974. And it will take a census round the room, even where you are seated, and the bulk of the people on this call joining virtually. I think that's 1974 is older than some of us. And that being the case, is no gainsaying that the law is outdated, is obscured. Now, being lawyers, as we have in this call, on this panel, and in this particular engagement, you will agree with me that our laws need to be reviewed periodically, maybe 10 years, and on and on. So when you are applying a Labor Act that has been in existence since 1974, almost 50 years, then you begin to look at some of the provisions. For instance, if you look at some of the provisions, they'll be talking things like still 1 naira, 10 naira, and look at certain other provisions in the current or in the extant act, you will discover that the act has been left behind due to new emerging international trends, whether at the ILO or recent pronouncements from the NIC, or recent happenings, even in the world of work. And so there is need for it to be reviewed. We totally agree with that. So we do not support that the act is fine in its current form. Having said that, sir, we'd like to let us know that steps have been taken, even by social partners. What I mean by social partners, I'm talking about the Federal Ministry of Labor and Employment, the NLC, Nigerian Labour Congress, the Trade Union Congress of Nigeria, TUC, NECA, and even with technical support from the ILO in reviewing our extant labor laws. I'm not just limiting it to the Labor Act, but I'm saying labor laws because this includes things like the Trade Unions Act, the Trade Dispute Act, the Trade Union Amendment Act, and even the Labor Act and the whole gamut of labor and employment laws in Nigeria. NECA was part of the discourse, and I was privileged to lead the delegation on behalf of employers in Nigeria. And we had several meetings, both in Lagos and Abuja. And we had recently concluded our review, I think on this August 2022 in Abuja. And what was agreed was that, yes, this is a draft. The Federal Ministry of Labor and Employment will send it through, we'll prepare a memo where it send it to Federal Executive Council, FEC. From there, it will go to the National Assembly as an executive bill. Thereafter, the legislative activities will commence. We had, in our review, drew the attention of all social partners to the fact that certain provisions need to be completely removed, and there will be need to introduce certain provisions so that we'll be in line with international best practice, current trends, ILO conventions, treaties, and even with the recent innovations which the NIC had actually brought to bear in our labor law jurisprudence. So the way it is now is that the whole lot of changes will be coming in. Not just from the title of the Labor Act or the Factory Act or the Trade Union Act, not just from the names or the titles, but even up to the content and its implementation. So what we are really waiting for is to know updates. I'm glad that the legal advisor of the Ministry of Labor and Employment is on this call. I saw him make a speech a while ago. And one of the things we will be expecting is that by now, the ministry would have done the needful, and then he will be able to guide us as to where the current or what the current position in terms of those bills, whether they are the FEC or whether they have actually gone to the National Assembly. The need to review this law is not something that we can debate or just talk about or sweep under the carpet, because there's a whole lot of things that have been done. And a while ago, I saw Elena Silk, Kuti SAN, and I think he was at the very first leg of the review. He just strolled in when we were doing the first round of the review at the hotel, and he breathed in for about 5-10 minutes before being excused again. So he will also confirm what I've just stated in terms of our position in the review. So NECA, being the employer's voice, is quite pleased that this exercise is being undertaken. We only pray and urge that the National Assembly will give these bills the attention it requires so that Nigerians, employers and employees, and everybody will breathe a sigh of relief. The reason why we're talking about it this way, and passionately so, is because at the last ILO conference, there was a case reported against Nigeria in terms of unfair labor practice. And certain provisions of our law was being hinged upon, like, oh, let the Committee of Standards, let the Committee on Application of Standard, CAS, look at it, review it, get the social partners involved, the Nigerian government, which we have done recently, so that those things will be changed for good. I think I'd like to pause at this point in terms of my preliminary comments, sir.
Thank you very much for that extensive background, Mr. Fabio. And I think that really sets the tone for much of what we're going to be discussing today. Like Mr. Fabio mentioned, I'm one of those people that the Labor Act is older than. And I'm sure if we were to take that poll, it probably be 100% that is inadequate. So we'll be dovetailing into specifics now to various areas of the Labor Act, both thematic and as specific as sections that we think need reimagining, to use the theme of this panel. So Natalia, I'll ask you to please go into the next set of questions.
Thank you very much, Jamiu. So I'm actually also one of those the Labor Act is older than. Okay, so the next question is for Ugo. It's a good thing you are beside me here. So now the Labor Act, still on it, has some limitations, and that's one of the things it's been criticized for. It's been said that the scope of its application as it relates to workers is actually, limited, is restrictive, especially as to define workers as persons who are employed for unskilled labor. Now I have two questions really from this. The first is, would you subscribe to enlarging the scope to include all forms of employment? And then the second one is, what real impact do you think this will have on our labor sector? Thank you.
Thank you, Natalia. Good morning, everyone. For some of us for most of us here who do prepare opinions for clients in other jurisdictions, it's usually a head-scratching exercise for them when your opinion is prefaced by the words. Our Labor Act only applies to workers and not to everyone. And then you proceed to make a distinction between who a worker is and who an employee is. And it's not surprising, because for people in those jurisdictions like South Africa and the UK, you find that the labor space is well regulated. It's clear it's clear that, there's a plan to actually secure and protect the interests of many classes of employees. It's really a head-scratching exercise for them to understand why our Labor Act should be so limited. Reference has been made to the fact that the Act itself is very old. And that might be the reason, actually, why the Act is structured the way it is, why it focuses on unskilled workers. There are very few people here who can speak to the conditions between 1971, when I think the Act, which is the effective date, I suppose, of the Act. And I think probably a few people like Mr. Roland Otaro, might, recognize that at that time, we had just come out of the Civil War, and this is me strictly from the history books. This is me speaking strictly from the history books. So at that time, this was just post-Civil War. Oil had just been discovered. We probably didn't have the kind of skilled employment pool or labor pool that we have now. So I suppose at the time, there might actually have been good reason for there to be focus on a lot of the pool at that time who would represent unskilled labor, which then meant, of course, that, there was less focus on, the other parts of the pool, which are the people who carry out what we always refer to as administrative, technical, and management functions. Of course, since that time, a lot has happened in this space. Technological advances, economic growth and recession, as it were, education, a lot has happened that has changed the dynamics of the labor market. In fact, for some of us here, the labor market or the labor system that we have now, post-COVID, was probably different in 2019 or 2020 post. There's a lot happening now that we didn't think was possible. Post-COVID, I hadn't been made partner in my firm, so I could say I'm still an employee, but I was, a much more standard employee at the time. And, hearing that we could work from home, that remote working was possible, and these were things that we never contemplated when, we were called to the bar, years much earlier. So clearly, a lot has happened that does not fall within the spectrum of the Labor Act. So if I sit here and say, in my view, that there is no need to expand the scope of the Labor Act to cover all forms of employment, many here will think that I'm speaking bulaba and balabu, because it's clear that we need to ensure that everybody is captured under that, under the spectrum of the Labor Act. I mean, we have the unskilled workers, we have the who we can refer to as the skilled workers, but over time we've also had forms of atypical employment, employment forms that are not standard forms of employment. So you have, part-time employees, you have employees for fixed terms, you have casual workers, you have remote workers, you have people who are subject to ambiguous and non-contractual forms of employment. The truth is there has to be, a legal framework that captures all of this.
Maybe. But I think we got the gist of your response, which is we need to enlarge that definition.
Yes.
And bring in all forms of employment as much as is possible.
Yes. And just to conclude, I mean, there was a second leg to that question, which is the impact. And really,
yes,
the key impact is certainty, right? Because, I think there was an opinion I read that had been done to a client, and the response from the client was that this response is so equivocal that he's not even sure what to do, right? It's not clear what steps he will take, and of course we put everything subject to determination by the NIC and all of those things. So I think the key thing is certainty for everybody involved, security for the workers, certainty for the employers of labor, certainty in the space. I think if we have a robust, legal regime that takes care of all of this, and of course, as you mentioned, the Labor Act is the primary, focus, or should be the primary focus of the labor and employment space. So we should have a robust act that actually deals with all these different issues and just makes sure that everybody is properly gathered into that umbrella.
Thank you, Gona. I think, during the course of the conversation, we might be calling on the representative of the Ministry of Labor because of their key role in addressing some of these issues. I know there are a lot of interventions that are going on right now, and it would be good to get their perspective on what the ministry is doing with regards to the review of the Labor Act and other legislations. Like Mr. Akpabio mentioned, I think, was it last year or 2 years ago, the Minister of State for Labor sent out a memo asking for proposals or suggestions on amending 4 principal legislations. But we'll get to that. You mentioned skilled labor in the course of a presentation. And I think the only person on this panel who requires a lot of skilled labor will be Mr. Ijeoma. And post-COVID, we began to, was it post-COVID or before then? I think one of the main issues we're facing as a country right now is the mass migration of skilled workers to other countries, presumably more favorable clients. And it's been so pervasive that it has led to the creation of a new word. We call it Japa, which is just to escape. And it's really a problem for businesses, as we know. So, Mr. Sige, do you think that the issue of skill shortages is something that regulation can help address, or is it a normal phenomena that we should just allow play its part? If it's something you think legislative intervention can help with, how best do you think businesses like yours and the regulators could work together with government to stem this tide and ensure that our labor sector retains a very skilled pool of talent?
Yes, thank you. Very happy to be here. Hello, everyone. It is a significant problem we're facing right now with the advent of so many people, skilled workers, leaving the country and moving out. One of the things is it's also like we're, I would say, in the perfect storm because it's really as a result of issues beyond the control of companies like Verify Me Nigeria. A lot of the young folks who are leaving have aspirational dreams that they feel they may not be able to attain in Nigeria because of maybe some conditions in the country. So the first thing I would say that's going to stem the jackpot tide is really maybe an overall better living condition that provides some sense of better hope to people. And it's really the only thing we can do about that really is for all of us to get involved in our government to continue to improve conditions. But really the JAPA is as a result of it. Do I think that there's regulation that we can put in place? I really do not see how we can put regulation in place. What I see that we can do perhaps is the government can help put interventions in place. Because, as a free country, people are allowed to pretty much leave and do what they want to do. But we can put interventions to potentially make it more enticing for skilled workers to continue to stay in Nigeria. We should put interventions, for maybe young people, maybe if they had better safety. I can tell you, for example, because people work from home, I've talked to very young developers, for example, and this is just an example of Japa who left the country, and they even went to places like Kenya and Ghana because and they were doing well here, working remotely and making dollars, working for international companies. And I asked them, I said, why did you leave? And just this is a true Japa story about something beyond your control as a business. And it was like, well, in my neighborhood, people were making me, and sometimes even, officials, log into my app and transfer the money out of my account. And there's nothing I can do. That had no safety. And where do you go? So they're really serious there's serious environmental issues that we really need to face. The other day I posted on Twitter is we should not create conditions that push people out of the country, literally. Because what they're going to do is they're going to look for a better life. So that's actually the first thing that we need to stop. Now, onto things in our control. Interventions, maybe we can look at how we can provide, tax reliefs, maybe programs for, buying homes or quality of life improvement for people that the government supports, because it's a real national security issue when you don't have people to build your country. We talk about doctors leaving, which is really a critical issue, but also when the engineers are leaving, right? The engineers are also, keeping a lot of the equipment that the doctors are using up. Or, the other day we had payment issues And, our partner, the bank, is like, we're so sorry, all our engineers have left, the payment system is not working, it's been failing, and we're, trying to patch things together. And the government needs to look at it as the possibility of crumbling systems, right? And really get together in an emergency way to deal with this situation of Japa in Nigeria. Now, the final thing I would say about that is, from an infrastructure perspective, another thing we can do, and Mr. Go, I think, talked about safety, is that when we look at the labor laws in Nigeria, we also need to look at how we can put in measures to create safer work environments. So, for example, the concept of making sure verification is done. We also have so many, issues with this, where people are not safe in their environment because companies are not doing proper reporting. So people who commit, even sometimes, crimes in other places, can just waltz into another workplace, and there's no verification infrastructure. So as even the government looks at e-government, looks at the use of NIN, which is our Nigerian identity number, we should also be looking at how to leverage operators and companies like VerifyMe to help the hiring industry in proper verification process. So not just identity, but even being able to share additional data so that employees who are doing their work can be safe, also from people who, and so that we can, I would say, remove people who shouldn't be in that environment from the work environment. Thank you.
Thank you very much, Mr. Sige. I think you've given quite a number of things for us to think about. And I guess the government is also thinking along the same line. We recently had the Startup Act, which I think tries to give some incentives to emerging companies. But we'll get to more of that later. Natalia, you have more questions.
Yes. This question is directed to Mr. Manuel Abraye. So, in the past, it was quite, easy to define the relationship between the employer and the employee. But that's becoming a bit difficult considering the new work emerging from different angles. Example, like the, platform works, agency work, and the rest of it. So looking at the Labor Act the way it is, what do you think is the best way this can be accommodated? Thank you.
Thank you very much, Natalia, and good morning, everyone. Well, so currently today we have forms of work that are not what we are ordinarily used to. The Labor Act, for instance, create a relationship between a worker, the worker's employer, and then, of course, the contract of employment itself, But we are having situations today where people are employed, in quotes, but they are not exactly employees. And like you said, platform workers, for instance, and you have them in a situation where they have to provide the work, but they don't get to enjoy the benefits of being called employees. Of course, we are all aware of the case that was instigated up to the Supreme Court in the UK against one of the ride-hailing companies. And in that case, the employment tribunal had held that, look, these platform workers are employees. You cannot, tie them to be called independent contractors. And by that, you shield yourself away from certain responsibilities that you should ordinarily have towards them. The ride-hailing company appealed to the Court of Appeal in the UK. The employment tribunal's decision was upheld. They appealed further again to the Supreme Court. That decision was upheld. But you have a situation where it's not the same everywhere. There was another case in Australia where the court said, look, no. Oh, I'm sorry. I'm sorry. And so you also had another case in Australia where the court said, look, no, they are not employees. They are independent contractors, And we had a situation like that in Nigeria. Unfortunately, the case really didn't see the light of day because pleadings were a bit faulty and the case was dismissed. But there was Oladapo versus Uber Systems Nigeria Limited, which would have, given us, what would have expected to see, But the Labor Act as it is says, okay, you're a worker, right? And even limits who you can define as a worker. Mr. Oguna has, given the reason why that must have been, especially because the Labour Act came, quite long ago. Now, what then do we do in a situation like this? Of course, we see what the National Industrial Court is doing. We just have the reality on ground is really just that companies are leveraging what the environment, is presenting to them. So you had a situation where before it was really just slave trade. Then enactments came and said, look, no, they have to be workers. Then you had fire your boss. Why should you have a boss? You can be your own boss, And so you now had people who now evolved into who Jack Sperretti called precariats, because they were in very precarious situations, living from hand to mouth, but being one-person corporations, And I was in one of the, of course, I can't mention the name, but I took a ride recently, and the driver was complaining to me about how he can't decide for himself who he picks. And that if, for instance, you as a rider tell him that you want to go to a place where, for instance, the roads are bad, he cannot do anything about, refusing the trip, because if he does, his driver ratings will drop. And then as his driver ratings continue to drop, he might get blocked off the platform, right? Now, that platform provider is exercising some form of control over that driver, even though they want to say, oh, no, he's not our employee. The platform itself has employees who are enjoying certain kinds of benefits. In fact, stupendous benefits, right? But the driver is, called an independent contractor. He's not entitled to all of those benefits, So we need to come to a point. Of course, I know that Section 91 of the Labour Act in defining an employer, did quite well, in involving the agents of, whoever that employer is, involving the personal representatives of whoever that employer is, because sometimes you have very real scenarios where, for instance, a joint venture has been set up, 2 different companies or 3 different companies are together, and you have employees just rolling around these companies and really cannot say, who their employers are. And, when the, purpose for which the joint venture is set up is established, everybody goes home, nothing, for it. So we have to come to a point where the Labour Act has to redefine who an employer is, redefine who an employee is. Of course, we have other legislations that define these things, but, still they do not really take into cognizance what the reality of, work today is, of course. And having some of these decisions we have from, different jurisdictions, enlarging this scope of who an employer should be, or who an employer should be, an employee should be defined as, we can actually key into this. And, bottom line is that the Labour Act as it is does not cover all aspects of the current workplace, and employees who should rightly be defined as employees. Of course, the National Industrial Code has always, looked at the primacy of facts when it comes to events like this. And of course, there's also the control test. Who is exercising this control, and you cannot remove all of these incidences from defining who the employee is or who the employer is, and who liabilities or responsibilities should go to, in situations like this. So I feel that the Labour Act, or I believe the Labour Act, has to be amended, especially in clearly setting out who the employee is, who the employer is, properly defining these terms to cover all of these new types of work to ensure that employees are rightly protected. Thank you.
Okay.
Thank you very much, Emmanuel.
Yes, Emmanuel, while you were speaking, I was just thinking in my head, when you look at the fact that, so this is me exercising the moderator's power to ask my own questions now. The principal legislation would have a broad definition of the relationship. An employee or a worker is someone who has written, oral, implied contracts, manual, clerical, administrative. Do you think that is not enough to give that broad scope to bring in all these other forms. So whether you are a platform worker or you're coming through a third-party PNN agency, as long as we can distill that relationship of providing services, do we really think that part of the Labor Act, I think it should be Section 91, is really inadequate? But maybe you hold that thought till Q&A. It's just something I was thinking, because we have to amend for every situation. I'm not sure we'll not wait till our own children's generation to talk about another amendment. But talking about what is patently inadequate, and now we'll turn to Mr. Akpabio. A 1974 law providing for penalties, wages. Of course, you read the Labor Act together with the National Minimum Wage Act, for instance, which I think the national minimum wage for now is 42,000. Is it 46? Which 30,000, which cannot bag a bag of rice suddenly anymore. And it's very, very, it's alarming. I can say personally, when I was invited to come to Abuja, I almost had to weigh the option of whether to come by night bus. Whether to go by night bus or spend over 150,000 just to get to Abuja. And it gets you thinking, cost of living for employees, the average employee, imagine someone who is on minimum wage, for instance, and he can't buy a bag of rice or even take a trip. Because I was speaking to someone the other day, and even this night bus I'm thinking of taking, some of them as high as 30,000 naira now. So, NECA, this is not to put you on the spot, but really, what can we do? You have rising inflation. Yes, we know it's a global problem, but how do you think employers can help or assist to not wait for another amendment of the Minimum Wage Act, but what are the things you think we can do from the employer's perspective to cushion some of the effects of the skyrocketing cost of living, both from an employer side and even maybe regulatory? I know the simple answer to regulatory is, okay, increase the minimum wage by fiat, by legislation. Of course, we know the one that has been increased. Not all the states are paying it anyway. So where does that leave us? What can the employers do to cushion the cost of living adjustment issues we have presently?
Okay, thank you for your question. Can you hear me again? Yes. I would like to thank you for taking the wise decision of not going by night bus, because the cost of it, including banditry, kidnapping, versus the cost of the etiquette, I leave that to take that decision, which is more expensive. Yes, national minimum wage is 30,000, but it's time bound. And very soon, the discussions and negotiation will come up for the review of that. However, pending when that is done, for organizations that are in the unionized environment, you will agree with me that they have a structure which is called the collective bargaining mechanism, which is done sectorally, whether in the food and beverage, in the manufacturing, in the chemical, and on and on. Now, some of them are done yearly. I know that in some sectors like the maritime shipping, oil and gas, while some are done every 2 years, while some are done every 3 years. Now, this also helps to shoot up the amount in terms of what is being paid. Please note that the minimum wage doesn't mean that that is what is being paid across the industry, especially in the private sector. Now, we did a survey where we went into all sectors and answered, what are you paying as a member company of NECA in your sectors? And what we discovered was that what they were paid was even higher than the national minimum wage of 30,000. So what that simply means is that 30,000 is the lowest, is the benchmark. So you shouldn't go below that, but you can go above that. I dare say, or I make bold to state that there is no collective bargaining currently in Nigeria that goes below that. In fact, some of them are even far higher than that, so that you begin to know what is being paid across the industries. So minimum wage mechanism, collective bargaining mechanism across various sectors, even with sectoral unions and employers association. And then even in the industry, when I say industry, plants, each individual companies, there's something called annual appraisal. And this is being done annually. Now we're at the end of the year. And then some of these appraisals are done either across the board, then in addition to it being done across the board, maybe 10 or 15% across the board, then there are some that are performance-based or target-based or bonus-based, also across for those that are merited or able to get it. That also adds to whatever they're taking. Then apart from that, I'm aware that there are also situations where people come to negotiate COLA, palliative. Oh, please, could you come up with a palliative just to cushion the effect of what is happening, and we call it COLA. So when those things are being put in place, the outcome of it is that the amount certainly shows off. Please note that I don't think any law can actually cure effectively issues of inflation or rising cost of living. Like you rightly said, it is a global thing, and on and on and on. Because if we're going to go by way of a law, I can tell you, if we go by way of the law, a whole lot of things will not be right. For instance, I don't know how much they're selling fuel in Abuja, but I know how much I got it in the filling station here in Lagos. And it's being touted that the amount might likely increase because of the landing costs and that which the marketers are going to give out to the final consumer. So the issue of a law, the issue of legislative, it shouldn't come in. It should be one of the issues of relationship, best practices, what has been ongoing within the industries across the board, so that is being implemented. Now, this gives rights, I'm sorry to state, this gives right to the fact that employers and employees need to make or place more demand on government, because the factors that ages of inflation are not purely labor-based, they're economically based. And this issue of inflation or cost of living affect not just the employer, but the employees also. So while the employer is complaining, the employee is also complaining. Why? Because they both buy from the same market. And the issue of inflation or cost of rising will affect the purchasing power of both the employer and the employee. So I just want us to take that and note those points so that we could factor it in, that employers are actually doing something which is an ongoing engagement. Thank you.
Thank you very much, sir. Thank you. Natalia.
Yes, thank you very much, Mr. Akpabio. So I'm taking this question to Mr. Asige. COVID-19, it really opened up a lot and took our minds to, different things that we never knew could happen. Now, most workplaces are actually looking at the hybrid work arrangement. Now, the new trends of employees really are now beginning to consider this flexibility as one of the decent, one of the consideration really for a decent work. Now, my question to you is this: how can organizations like yours create opportunities for purpose-driven work and accommodate hybrid work environments to be more effective? Thank you.
Yeah, no, that's a very good one. And I think that COVID-19, kind of forced a lot of organizations to move to, first of all, a more distributed model where everybody is working from home. Being a tech company, interestingly, we were already prepared to be all remote. And I can tell you, we still have a very strong hybrid model where it's actually mostly remote for a lot of our engineers. A lot of the younger ones, they're not trying to come back to the office. And somebody even mentioned it, when you look at what your employees have to go through to get to work, where it's 3-4 hours, you also have to factor how that impacts your own productivity. And so we were able to make decisions to continue to keep, our team members, and we were prepared for it. In fact, we continue to see very strong performance with everybody at home. And one of the things is you need to make sure that you have measures in place for one, a collaborative work environment. You have, platforms for communication. Your cybersecurity is in place where you have your company internal boundaries where employees can log in for information or log in to collaborate on work. So that's one of the things. Now, speaking to taking it into a purpose-driven work environment, we really relate that, to our team members really having ownership and understanding of the reason they are doing their work. And that's really related to making sure that that collaborative environment, that's number one, and making sure that they have proper training and line of sight between the company's goals, what we want to achieve, and the activities that they have every day. And you do that, first of all, through multiple ways. Number one, and someone alluded to this, having happy employees or people who are who are not having to think about the hardships outside. So this is one of the reasons, for example, why the many in the private sector pay much higher than the minimum wage. The other way is, you make sure that they have the tools, technically in a collaborative environment, to be able to work together and have the training to understand. You provide a safe environment with proper verification, so that people who are not in their environment or, distractions, causing problems in their environment, are not there as well, which we all do very successfully. So these are some of the ways, you continue to, kind of work with your employees so that they have that purpose-driven work environment. And it's really, technology is at the center of it. It almost cannot be done without technology, particularly when you're talking about team members understanding their KPIs. A lot of times these days you're measuring these KPIs using technology. And the technology is not going to be able to measure those KPIs if you're not putting the data in a collaborative environment. And you're not going to be able to put the data in a collaborative environment if the people that are doing the work don't understand what type of data that they need to create as a condition of their work. So this is how everything is really related. And this is why they say people process things, right? In business, in terms of, people process tools in business in terms of creating that collaborative work environment. Thank you.
Thank you very much. Jamiu?
Yes, thanks, Natalia. So, all we've been talking about so far this morning has been about the need to review the Labor Act to accommodate all these modern day realities. But I think recently someone pointed out a very germane point, which is that perhaps we are not making the best use of what we have already. So amendment is good, but even in the best of jurisdictions, amendments don't come every year. I have written a book on the subject matter area, and within 2 years, you see how almost totally outdated everything in that book is. So that tells you that even in the best of situations, legislation may not be able to keep up with development. But the regulators have a role to play, and perhaps more leverage than they are using. So if you look at some sectors, the oil and gas sector, for instance, yes, maybe the Ministry of Labor is beginning to do more of that. You see that the Labor Act gives the powers to the ministry, especially, to issue guidelines on so many things. So, Ugonna, do you think we are making enough use of that leeway, which is, for want of a better expression, making new laws by way of guidelines that will take into account emerging issues Recently, we had guidelines issued by the ministry for outsourcing issues in banking and other financial institutions. I think there's one that has been issued on outsourcing in the oil and gas industry. We've had, I think, maybe in insurance companies too. So do you think that is more of what we should be seeing rather than being fixated on we must amend the Labor Act to make progress? What's your view?
Jamie, I totally agree that in the absence of an amendment, which clearly has taken ages, we should explore that, if you will, a stopgap alternative of using guidelines and regulations. The problem, of course, is that an amendment is the ideal situation because creative lawyers will always find a way to question the validity of, guidelines or regulations that may be issued at any point. For instance, Section 88, 1E and G of the Labor Act is what gives the minister those broad powers to issue regulations. The challenge that experienced and creative lawyers would put forward is that if you look at the language of that provision, it says that it allows the minister to make regulations to prescribe anything which is to be prescribed under the act that is not otherwise prescribed, or containing ancillary or procedural provisions that he considers necessary to facilitate the operation of the act. The problem is that if the focal position of the act is to regulate unskilled workers, and you have a few provisions that apply to Sorry for the break in transmission. So an argument can be made that you can't then make regulations that will draw away from the focal operation of the act. This is just, theoretical. I'm not saying it's been canvassed anywhere, but I'm saying that in challenging the validity of guidelines, this is just making the point that the ideal situation is to amend. However, we can rely on those guidelines provided that it can be shown objectively that those guidelines do not fly in the face of the purport and intent of the act. So people can argue that the act really serves to regulate unskilled employees. So if you don't issue guidelines that then relate to people we can refer or classify as skilled employees, people who exercise, administrative management, technical functions, you might then have a problem. But I completely agree that we need to look at that more. And as you said, in recent times, there's been a push to do that. I think the guidelines for contract staffing in the oil and gas industry was issued as far back as either 2011 or 2014. I'm not sure now. But in recent 2015, But in recent times, we've also seen, as recently as September 2022, the guidelines were issued to regulate, contract outsourcing, contract staffing in the banking, insurance and financial sectors. In fact, just a few minutes to even highlight that particular guideline. The class of employees that guideline refers to are that class is one of the most abused class of employees for such a long time. Contract staff have been used, just fire at will. There is no path to career development. There is no increment in salary. You just exist at the pleasure, of the employer. In fact, when it got inconvenient for the employer to even hire them directly, you just go to labor brokers and just have them bring them in. Whenever you feel like you terminate the underlying contract and move on with your life. But the benefits of guidelines and regulations can actually be seen in the provisions of this guideline that was issued on the 8th of September 2022. Among other things, the guideline provides for entry requirements. It provides for minimum pay. In fact, if you look at the provision on minimum pay, it says that there has to be an annual increment on salary, which would, of course, help alleviate some of the issues that we face today from inflation. It also talks about the fact that there should be opportunities for career advancement within 2 years, but not later than 3 years. It talks about career path and development. Very important. The opportunity to be assimilated, to move from that non-permanent position to a permanent position, of course, depending on the recruiting standards and processes of the employer. It talks about unionization, which is important because, as was mentioned earlier, if you have a collective bargaining agreement that these people can partake of, it then helps deal with some of those exploitative practices that we usually see. So, in fact, the guidelines actually says guarantees the right to unionization, and then specifically mentions the unions that that class of employees can belong to, as appropriate. Of course, there's collective bargaining, there's disciplinary procedure. For the most part, if you look at some of the cases relating to contract staff, you find that once, particularly in banks, you find that once there's an issue, money has been lost somewhere, immediately the next day you're off. Because you're not regarded as a permanent employee, there's no established process to ensure that you're heard fairly. The guidelines takes care of that, ensures that you're entitled to fair hearing, you're entitled to fair representation, you're even allowed to attend some of those disciplinary proceedings with somebody who can represent or canvass your position. So the point is, looking at these particular guidelines, which affects a very underserved class of employees, we see the benefits that we can derive. Yes, there might be issues relating to validity, which can be dealt with by the courts when they arise, but we see benefits that clearly, come into play when these guidelines are put in place. Of course, they're the more controversial ones. For instance, the one on the release of employees in the oil and gas industry, which many of us, find to be, at least employers of labor will find it to be tedious in dealing with their employees. But that's why we have the National Industrial Court. The court can deal with, the validity, considering the validity or otherwise of those guidelines. But to be honest, that's probably the best way to go in the absence of an actual amendment of the Labor Act.
Thank you very much, Ugonna, for taking some time on that. And again, it's good that we have colleagues from the Ministry of Labor, because I think there's also a balance issue here. When I look at the new raft of guidelines that have come in, I think the point had been made to say, okay, is this not more of a restatement of the law, and you still leave quite a whole lot of issues left to, as we say, where both parties agree or subject to what? So are you really prescribing or just highlighting the fact that you can both come to agree? So I'm looking at that, I'm balancing it with the one you mentioned from the old DPR, which is you will do this. This is how you will do it. And on the other side, one that is saying, okay, yes, they should have the right to unionize. They should have right to permanency, minimum pay, but let it be based on mutual agreement and all of that. And you wonder, okay, so what's the thought process behind this? Do you want to cause a change, or do you want to remind people of what they should be doing? So, but I guess we'll be happy to have someone from the ministry also throw light on that, maybe when we get into Q&A. But let's move on to a few more questions, and then we'll do Q&A. For those who are online, you can drop your questions in the chat box, and we'll endeavor to take as many questions as we can from online and from the room at the end of the day. So, Natalia,
yes.
Question.
Thank you, Jamiu. So my next question is actually going to Emmanuel. But before I ask this question, I want to just mention something, because this area happens to be related to family, really. And one of the things the Labour Act has been criticized for is